my lord, to your lordship, my lord. There are two volumes in this before your lordships. One, my lord, purple volume, and another, my lord, is orange volume, my lord. My lord, in this first decision, my lord, I am trying to realize, my lord, Ajit G. Das versus State of Kerala. In that case, my lord, the government requested the commission to, my lord, send candidates over and above the notified number of candidates. My lord, the PSC refused to send it on the ground saying that there is a rule, my lord, as it is here, saying that the commission will not select the candidates over and above the notified. When the matter went before the Kerala High Court, Kerala High Court took the view that, my lord, it is an autonomous body. Government cannot force its views on the PSC. My lord, in such situation, the Honorable Supreme Court was pleased to deal with the issue. Can I? Lord, I'll just try to take your lordships to the relevant paragraph. Lord, paragraph 8, kindly take to. The appellant subsequently approached the High Court challenging the tribunal's order. The division bench of the High Court, through its common judgment, dismissed the petition, affirming the tribunal's decision. The High Court held that while the government serves as the employer, Kerala Public Service Commission functions as a selection agency. Neither the government nor the tribunal nor the court has the authority to direct the Kerala Public Service Commission to modify or expand the rank list to address unfilled vacancies. It was reiterated that Kerala Public Service Commission retains full autonomy in such matters. Aggrieved by this decision, appellants have filed the present appeals before this court. The High Court, in its impugned order, emphasized that the autonomy and constitutional independence of the Kerala Public Service Commission in the recruitment process, asserting that any interference by external authorities would undermine the intended purpose. The High Court extensively deliberated on the autonomy and constitutional responsibilities of the KPSC while addressing the question of whether KPSC is obliged to act upon the recommendations made by the state government regarding the expansion of the rank list. The High Court understood that the KPSC, as a constitutionally mandated autonomous body under Article 320 of the Constitution of India, is independent in its functioning and decision making. The High Court highlighted that the Public Service Commission's independence is enshrined in the Constitution to ensure fair and transparent recruitment, free from influence or arbitrariness. It highlighted that the government cannot interfere with the authority to prepare rank lists as that would undermine the independence of the autonomy, which are vital to the ensuring the transparent and fair recruitment. While the government, as the appointing authority, has the right to make recommendations to the Public Service Commission regarding the number of candidates required, such recommendations are not binding on the Public Service Commission. The High Court emphasized that the Public Service Commission has the discretion to either accept or reject these recommendations based on its established procedures and the constitutional mandate to uphold the fairness in public employment. High Court clarified that neither the so and so nor the courts have the authority to direct rank list of or alter the decisions regarding the selection process. It held that such interference would compromise the independence which the Constitution explicitly protects. High Court outlined the framework of the recruitment process which involves. Kindly, my lord, omit the rest of. Then kindly go to paragraph 15. are the contentions. My lord, paragraph 16 is the finding. Contentions, my lord, if your lordship permits, I'll omit. Can I omit the contentions? Finding is at my lord, paragraph 16. Having considered the submissions made on behalf of the appellants and having perused the material on record, we find merit in the appellant's arguments and believe that it is imperative to look into the limits of the autonomy and its powers vis-a-vis the state government. Having considered vis-a-vis the state government with regard to the selection process and employment in government service. Primary role of the PSC is to aid and facilitate the selection process. It functions as an autonomous body within the framework laid down by the Constitution of India, ensuring transparency and merit-based recruitment. However, its autonomy is confined to the conduct of selection process. Determination of the number of vacancies and requisitions for employees remain the prerogative of the state government, which is the employer. This fundamental distinction was overlooked by the High Court, leading to an erroneous interpretation of the authority. Government's role in notifying vacancies is integral to the recruitment process. It determines the workforce requirements based on the administrative exigencies and operational needs. The PSC's mandate is to conduct the process in a manner that aligns with these requisitions. The present case underscores the need for clarity in division of responsibilities between the state and government and public service commission. Pausing for a minute here, my lord. I have yesterday taken your lordships to GOMS number 16, issued on, my lord, in February 2024.
Yes, yes.
My lord, in February 2024, on 3/2/2024, my lord, government issued GOMS number 16. It stated that please take steps for conducting or not selecting the candidates for 60 vacancies, the details of which were to be furnished by the authorities. Not the PSA acts over and above that. It seeks to, my lord, cancel the notification by its, my lord, decision dated 19/2/2024. My lord, there, my lord, this paragraph in my humble submission applies in that such situation.
Yes.
The the Public Service Commission's mandate is to conduct the selection process in a manner that aligns with these requisitions. The present case underscores the need for clarity in the division of responsibilities between the state government and the Public Service Commission.
Yes.
Then, my lord, the other paragraphs may not be relevant is the submission that I made. Then, my lord, there is a possibility of the submission that the government is in tandem with them, in the sense that, my lord, it's not the PSC alone which has taken a decision to cancel the earlier notification, but it is the government also which is in agreement with it. My lord, in that situation, my lord, two more latest decisions of the Honorable Supreme Courts do say that even that course is not open to the government also. My lord, with your lordship's kind permission, my lord, kindly take Mandeep Singh versus State of Punjab. Can I read from just for the purpose of facts? If your lordship permits, I'll read paragraph 2. At page, my lord, 18, it starts. Can I, my lord? Challenge the judgment of the Division Bench of the Punjab and Haryana High Court, which has reversed the findings of the learned single judge and has hereby upheld the selections made by the state of Punjab for the post of
Yes.
assistant professors and librarians in the government degree colleges of Punjab. The brief facts of the case are as follows. January 21, the state of Punjab had sent separate requisitions to the Punjab Public Service Commission for recruitment of 931 assistant professors and 50 librarians in government degree colleges in the state. Consequent to this, based on the correspondence exchange, the commission engaged 24 subject experts to prepare the syllabus for the competitive examinations and honorarium was paid to them. Later, an additional 160 posts, as it happened here, additional 160 posts of assistant professors and 17 posts for librarians were created and sanctioned for newly established colleges. And on 15/9/2021, the state's Department of Higher Education sought Commission's consent to fill these posts through the Departmental Selection Committee rather than the Commission. Commission replied by letter expressing their inability to respond on the ground of the chairman having retired from the service so and so. Then, my lord, kindly omit that paragraph, later part of the paragraph. A change in the government happened. Can I read D, my lord, with your lordship's kind point? A,
Yes.
a change in the government happened on 20th of September 2021, after which on 9/10/21, selection process was reviewed in a meeting chaired by the Secretary Department of Higher Education. In this meeting, the entire process of recruitment was changed and it was decided that selection would now be made only on the basis of a written test, which will be conducted by two separate selection committees of two universities, Punjab University Patiala, Guru Nanak Dev University, Amritsar. Further, it was decided that all 1091 posts which were notified to the Public Service Commission and 67 posts of assistant, 67 posts of librarians, and not just the posts recently created are to be filled through the departmental selection committees. This decision was placed for approval before the chief minister on so and so date, with the observation that it shall be subsequently be placed before approval of the council of ministers. Government is then emailed on 18/10/2021. Government issued a memorandum conveying to the director of public instructions the decision for recruitment of so and so, so and so. Then, my lord, paragraph 5, I'll now go to. These were the facts, my lord, of that.
Yes.
Paragraph 5. State and the private respondent would though argue that Article 323 is directory and mandatory in nature. They would submit that the state government is empowered to decide its own method and procedure for recruitment for the posts of assistant professors and librarians in degree colleges under the state government, and it is not bound to make selections though through the commission. Kindly, my lord, omit that part. Kindly go to paragraph 8. The commission has the duty to make selections for different services in respect to the requisition of the state government. In the present case, in January 21, state government had sent two requisitions for the recruitment of 931 assistant professors and 50 librarians respectively. Then, my lord, they have gone into elaborately
Yes.
the history of the PSC. They have, in fact, gone into the history of the PSC even prior to the constitution. They held what will be the powers of the PSC, etc. Then, my lord, kindly, that may not be necessary for our purpose. Now, my lord, I'll take your lordships to how, my lord, the court, my lord, approached the problem of whether the government can do this exercise. Paragraph 48.
Only to clarify, my lord, this is the only aspect which the learned judge held in our favor. They are not in appeal. But I just wanted to bring to your lordship's notice.
I'll
G, my lord, ground G is the one which is held in our favor. This aspect, my lord, has been rejected, and they have not filed any appeal.
This,
Again, my lord, same thing is.
I'll take. Will your lordships, can I just complete?
yes, please.
Paragraph 48.
Yes.
In short, we find that there is a total arbitrariness in the present selection. The memo of Council of Ministers dated 17/9/2021 shows that the state wanted to recruit only 160 posts of assistant professors and on 17 posts of librarians through the departmental selection committee on an urgent basis, as these were the newly opened colleges. As we have already stated, even those cases, the recruitment was to be made by following the UGC regulations. Next, the 931 and 50 posts of assistant professors and librarians, which were lying vacant and in regard to which the requisition had already been sent to the commission, were added, and it was decided that the sole basis of the selection would be single exam. Moreover, a mere 45 days deadline
Yes.
was set for the commencement and conclusion of the whole recruitment process, and ultimately within the span of 2 months, not only was the recruitment process concluded, but even the appointment letters were issued. One cannot fail to notice that burning haste with which this entire exercise was undertaken by the powers that be. It has thus been repeatedly pressed by the appellants that all this was motivated by political exigency in the form of impeding assembly elections in the state. Then, my lord, kindly go to, my lord, paragraphs 52, 53. The state and its instrumentalities have a duty and responsibility to act fairly and reasonably in terms of the mandate of the Article 14 of the Constitution. Any decision taken by the state must be reasoned and not arbitrary. This court has consistently held that when a thing is to be done in a post haste manner, mala fides would be presumed, and further that anything done in undue haste can also be termed as arbitrary and cannot be condoned in law. We may refer here to few judgments. Kindly omit those judgments parts, my lord. Kindly now come to, my lord, the paragraph 57.
57.
Yes. Lastly, my lord, we need to state that it is a settled principle of law that when law prescribes a thing to be done in a particular manner, then it should be done in that manner alone. Then, my lord, paragraph 58, 2, the state is entitled to change its policy, yet a sudden change without valid reasons will always be seen with suspicion. Even in cases where there is no statutory prescription or any particular way of doing a thing, the executive must observe the long standing practice, and a deviation from such practice would require passing the muster of reasonableness, which is a facet of 14 of the Constitution. In this regard, this court, my lord, kindly omit that judgment portion. I may now take your lordships to paragraph 59, last four lines, my lord, just above paragraph 60. In the present case, the state has miserably failed to justify the departure from the standard norms of the recruitment process. It has failed to give any valid reason for not adopting UGC regulations in question. Moreover, as discussed earlier, reason for this departure were narrow political considerations. My lord, this far will be sufficient from this particular decision. My lord, to the similar effect are the decisions at the at page 45, my lord, but they have just further elaborated. My lord, the issues were formulated at page 64.
This is the other judgment.
My lord, this is another judgment starts at, my lord, page 9. Sorry. At page 45, my lord.
Yes.
My lord, issues were formulated at page 20. I may, my lord, with your lordship's permission, read, my lord, paragraph 42. It is vehemently argued that the recruitment process was kept in abeyance and later cancelled based on NRP, New Recruitment Policy, my lord, NRP, which was a bona fide decision by the government in a larger public interest. In support of the said contention, in the counter affidavit, it is stated that the decision of the state shall be of benefit in long run because of qualified candidates shall be recruited on merit, which may enhance overall efficiency of administration in the state. Apart from this, there is no mention even in the new recruitment policy as to how larger public interest can be achieved by abolition of interviews. It is difficult to see how such larger public interest can be achieved in the
You are
present
reading
context.
from which page?
I am reading, my lord, paragraph 42, my lord.
42,
Yes. Your lord. Sorry, my lord.
page 79.
Yes, my lord. Sorry. It is vehemently argued. Can I read, my lord, from 42 again?
Please.
It is vehemently argued that the recruitment process was kept in abeyance and later cancelled based on new recruitment policy, which was a bona fide decision by the government in larger public interest. In support of the said contention, in the counter affidavit, it is stated that decision of the state shall be of benefit in long run because qualified candidates shall be recruited on merit, which may enhance overall efficiency of administration in the state. Apart from this, there is no mention even in the new recruitment policy as to how larger public interest can be achieved by abolition of interviews for Group D posts such as enrolled followers. It is difficult to see how such larger public interest can be achieved in the present context, specifically where the recruitment process for enrolled followers was at significantly advanced stage and interviews had already been conducted. Then, my lord, referring to several judgments. My lord, issue number 3, my lord, at page 85, speaks about legitimate expectation.
There are two pages, one at the top and one at the bottom.
Yes. Sorry, my lord.
Full of it.
Sorry. At the top, my lord, is the page nation which I gave. Bottom is the page number of that particular decision, my lord. Sorry, my lord. I'm sorry. I have not noticed that bottom number.
So which paragraph now you are referring?
I'm not page 85 at the top. Legitimate expectation and indivisible rights was discussed. Kindly omit that. My lord, they stated, my lord, that I have a legitimate expectation. That is, persons, my lord, who participated in or made application have a legitimate expectation. Kindly then come to, my lord, page 89 at the top. Paragraph 58. In the present case, can I read?
Yes.
In the present case, it is not that the state has decided to fill up only some of the available vacancies, but rather it has decided to do away with the recruitment process as has been done here. Earlier, 503 vacancies were notified. Later, only they wanted to fill up 60 vacancies by a subsequent recruitment process. It goes without saying that the state's decision not to appoint a person who has been placed on the select list must not be arbitrary and must be rooted in objective reasoning. Recruitment process, especially when it is conducted on the strength of act and rules, cannot be left at the whims and fancies of the state to interfere through executive orders without adhering to the principles of consistency and predictability, which are warranted by the rule of law and are pillars of non-arbitrariness. As discussed above, state has failed to prove that the decision to apply new recruitment policy to the ongoing recruitment process was in larger public interest, as such the legitimate expectation of fairness in the recruitment process must be upheld. This is how. Lord, next decision by the very same bench, my lord, but after this decision, my lord, in the High Court, it was pleaded saying that the matters are covered by the that decision. The High Court did not agree. Lord, same principles, Lord, were again reiterated. Same analysis went through. Lord, I may not read, my Lord, that decision also for you.
Now I'm just trying to find out the impugned decision where any time when I was there or not. when I was there, I was just trying to find out whether the impugned judgment is of that period or before. It is of before. This originates from Tripura.
It's from I,
Yes.
the decision note in that case. Your lordships will get
No, these are of 2019 and 21.
division bench may not 20, 25/8/2020 was the decision of the division bench there.
So
That your lordships will get at page 148, paragraph 10 will order. In the earlier decision, I'll just check up.
yes,
The second one is your lordships, the division bench wide judgment dated your lordships.
yes, yes, absolutely.
Murad, Murad, it may not be necessary that the same principles were reiterated. Therefore, Murad,
Very well.
will your lordships kindly permit me to read? Kindly take top page number at 326. But in this case, just before I read the relevant portion, at paragraph 2.2, my lord, your lordships will from the page 342 at paragraph 2.2.
Paragraph
2.2, my lord. Your lordships will find the date of the notification was 28/12/2006. And in the same my lord, written examination was held on 21/1/2007. So let's get. Then decision of the commission to cancel was on 1/2/2007. Then, my lord, it has taken a decision again to fill the very same, to go ahead with the very same notification but in a different fashion by conducting interviews alone. That your lordships will find it last four lines in paragraph 2.4. The commission has decided to shortlist 8 times candidates of the advertised post in the respective category for interview on the basis of essential academic advertised qualification. Notice also mentioned the minimum weighted score marks. Then, my lord, after that, kindly now come to top page 352. Issues were formulated by the Honorable Supreme Court. At paragraph 33. Can I read the issues, my lord?
yes,
Point. Whether the respondent petitioners who had participated in the selection were stopped from challenging the selection in the facts of the present case. Whether, my lord, I may humbly submit, the answer was given, if your lordships are kind enough. I may just say that answer was given at paragraph 45.1. I'll take your lordships to that answer slightly later, but answer was given at paragraph 45.1. Second one is whether the respondent petitioners could have challenged the criteria of selection applied by the Commission for selection after they have participated in the selection. Answer was given at paragraph 45.2.
Yes.
Then, my lord, whether the decision dated 30th of June 2018 to cancel the written examination and the decision dated 11th 2008 to call the candidates for interview 8 times the number of vacancies on minimum percentage of marks as listed therein, and the decision dated 31/7/2008 to call all the eligible candidates for interview were arbitrary decisions to change the selection criteria published on 28/12/2016, which has the effect of downgrading the merit in the selection. The answer is given at paragraph 63.1. Whether it was obligatory for the Commission as a body to take all decisions pertaining to selection on the post of so and so, including the decision of not holding the written examination, decision to screen on the basis of 8 times vacancies, decision to call all eligible candidates, and whether the aforesaid decisions were taken by the chairman alone. Then, my lord, whether that was answered, my lord, in paragraph 63.2. The discussion starting from 59.59. Then kindly go to 33.6. Whether without there being any specific allegations of malafide against the chairman and members of the commission and without they having been included by name as parties respondent, the petitioners could have challenged the allocation of marks in viva voce, and the High Court was right in accepting the claim that the candidates who got highest marks for academic qualifications ranging so and so have been awarded just 7 2 in the viva voce, and against it there were hurdles, hundreds of selected candidates who have been awarded so and so marks in the viva voce to ensure that they outclass the academically bright candidates. Answer is given at paragraph 64. Whether no fresh selection can be held as directed by the learned single judge, since as per rules 2012 rules, the post of PTI has been declared as a dying cadre. Murad, that was discussed, Murad, at paragraphs 70 to 80. Murad, may I just now take your lordship to Murad, these Murad, that is issues 1 and 2, Murad, in my humble submission, there is any amount of case law which your lordships are aware. Even if I participate in the selection, if I can point out the Lord illegality to your lordship, Lord, I can challenge the same. Lord, therefore, I propose to omit, Lord, the discussion on first two issues.
Yes.
So also three. Well, I may concentrate with your lordship's permission, my lord, on 33.6.
Yes.
My lord, paragraph 61 onwards. Can I read? Paragraph 61 at page 367. At this stage, we may note one more submission of Sri Kapil Sibal. Sri Sibal submits that when Commission published notice dated so and so, that no written test shall be held, the writ petitioners ought to have challenged the above decision, and the petitioners should have insisted that the written examination may be held. They having not raised any challenge at this stage, cannot be permitted to say that written tests ought to have been held. We having held that the change in criteria of selection was never notified, And about the change in the process of selection, the candidates were kept in total dark, and for the first time, criteria applied in the selection process. In view of the foregoing discussions, we answer points 3, 4, and 5 in the following manner. The decisions dated 30th of June were arbitrary decisions without any reason to change the selection criteria published on 28/12/2016, which have the effect of downgrading the merit in the selection. Commission being a multi-member body, all decisions pertaining to mode of selection and criteria was to be taken by the commission itself. There being no rules or resolution delegating the said power to the chairman or any other member. The decision of not holding written examination, decision to screen on the basis of 8 times the vacancies and percentage of marks, and decision dated so and so to call all eligible candidates for all decisions taken by the chairman himself, which decisions cannot be said to be decisions of the commission. The decision was never taken on so and so as claimed in the said resolution was prepared subsequent to declaration. Then Lord Kapil Sibal, Leonard Senior Counsel, has emphatically submitted that in the requisitions there are no challenges of qualifiers against chairman, etc. Then Lord, meeting that paragraph 67, the learned judge said, the present is not a case of malice in fact. Then, my lord, kindly go to paragraph 68.
Yes.
Thus, malice in law has been dealt as something done without lawful excuse. Malice in law is also mollified the exercise of power. Exercise of statutory power for the purposes foreign to those for which it is in law intended. In the present case, the power to devise the mode of selection and fix the criteria for selection was entrusted on the commission to further the object of selection on merit to fill up post in the state in consonance with the provisions of 14 and 16 of the Constitution of India. When the alteration of criteria has been made, which has obviously affected the merit selection, as we have found above, the allegations which have been made in the writ petition against the commission in conducting the selection are allegations of malice in law and not malice in fact.
Yes.
That far will be enough to note from this particular decision is the submission that I made. This is for the purpose of submitting the note, saying that the TSC firstly had no power. Ajit ji Das Milord, whatever is the Milord, whatever has been held in Ajit ji Das in a different circumstances applies equally to the circumstances Milord in this honorable court. For any reason it were to be said that this is the decision of the government also, the later three decisions which I have read to your lordship, my lord, would come to my rescue to say that all such decisions will be arbitrary. They will be affecting the legitimate expectations of the, and it will be unfair also. That concludes my submissions on the first issue, which I thought I should raise. Then, my lord, going back to the issues decided by the learned judge.
No, but what is the answer to the objection that is?
I'll make, after I just run through this, I'll definitely answer it. Well, ultimately, any, Lord, If I am correct, my lord, another writ petition was filed. I don't readily have the number challenging offending portions or which my lord, the writ petitioners feel that my lord are against them. Yeah, sir.
They are
I don't readily have the number, my lord.
alternative directions.
A separate inspection came to be filed before the learned civil judge at the time of prelims exam, questioning the answer
But
not to certain
I
questions, one second, to certain questions, in which this issue, my lord, with respect to power of the commission.
my lord, a
also
cross
raised.
appeal has been filed,
My
my
lord,
lord.
that inspection came to be dismissed, confirmed in appeal and also SL. That was brought to the notice of the learned civil judge, which therefore may not be held against the, my learned friends, counsel, with respect to, my lord, the aspect which is being argued now. As ground
But-
G, my lord, in the inspection, your lordship may see at page 279, on the ground which we did not argue. The
May-
reason
may-
is that it was held in our favor. The one which my learned civil judge
In
has argued.
respect of the 4 of 22 prelim exam,
And cancellation and then clubbing and then issuing a fresh
so
notification.
this was challenged.
That was challenged.
I
in
put it,
petition.
I'm not, I am aware.
Please allow
But
me.
question is, I do not know what is this.
Challenge up to
No,
Supreme
I am
Court
on my
and
legs. I have never interfered him.
settled.
No, we were just trying to clarify because in
But
our,
I put it this way. I am aware of those facts. I'll make my.
so therefore, when we are making the query, he is bound to answer.
There is no doubt about it. We are at command of your lordship.
The learned judge though did not refer to the writ petition writ appeal and SLP number. Learned civil judge simply said, this matter has already been decided by this court, therefore we are holding against the petition.
Those decisions or orders are there in the
They are not
compilation.
there, I can handle. They are not there, I can handle.
I submit.
One full, because I had appeared before the Honorable Supreme Court. 3 different stages, including the arguments my learned friend has made, were rejected by this Honorable Court, carried up to Supreme Court, and Supreme Court rejected it. So before the learned single judge, therefore, my lordships notes the arguments that were made. These were not within the ambit of consideration.
It's filed in the last compilation, Gopal Shankar Nayan sir's compilation, all have
Lord,
been
my humble submission is, it was never put in issue. I put it in another fashion. I know about those cases. It was never put in issue on the ground saying that it is not within the powers of the Constitution. This connection was never the issue that was raised. But it was raised in a different context. And a division bench of this honorable court, Lord, if I am correct, Honorable Sujay Pal and Radha Rani Ji, Lord, have held saying that the petitioners therein came to the court belatedly. And earlier to that, there was another writ petition filed that was also dismissed on the ground of delay. Therefore, the subsequent writ petition can also withstand the ground of delay. Therefore, it was dismissed is what the another division bench has said. I'll come to that, my lord. I have in my written submissions which I have given to your lordship, my lord, I have bestowed my attention on that. I'll answer your lordship, my lord. Let me not proceed the way I would like to proceed. My land friend may be anxious, my lord, to.
I am not,
my lord,
I am only answering the honorable judge. Para 338, the learned civil judge discussed about this.
I am conscious about it, but we are every day appearing, my lord, in all these service matters. Or in other matters also, we are aware of, my lord, what has happened in other courts. And we have stated so, my lord, in the written submissions. I'll just take your lordship to that.
No,
my lord.
the point to ask this question after hearing you on this issue for considerable time was just to be clear in our minds that if that point was either taken up to Supreme Court in another
It
petition
appears, my lord, it was taken.
and in the same
Vijay, my lord, it was dismissed.
in the impugned judgment also it was not answered in favor of the petitioner, then without any challenge to finding on that, if the
I have
appellant
not
can,
filed, I
if
have
the
not filed a
respon-
cross appeal. I have not, that's from our office or from the instructing counsel's office, my lord. There is no cross appeal, but I am told that there is a cross appeal. I'll come to that slightly later, my lord.
No, but in that case, developing that point to such an extent, will it be open to the respondents?
I'll answer it, my lord. It is open. I can develop it further. I may say that any decision on delay or, my lord, issues regarding, my lord, constructive res judicata or res judicata will not apply when a substantial point of power jurisdiction is raised and which was not raised earlier. I'll come to that slightly later. I'll try to substantiate. I, I know that such an issue will be, at least the objection will be raised by them. I have bestowed some attention on that in my written submissions is what I am trying to submit.
Yes.
Yesterday I was taking your notice to the notification which is there in volume 3.
Yes.
Yesterday I was taking your notice to the notification to submit. That the changes which they were trying to bring about or which they brought about after this notification, but beyond their power is what I was trying to submit after the notification. Just now till now what I have argued was prior to this notification. After this notification, whatever they have done was contrary to this notification itself was what I was trying to submit. But kindly go to page 358. Where the notification. Your process will find the notification. Kindly come to Lord.
Page?
Page 358 is the notification, volume 3.
Yes, yes.
E58 bottom, paragraph 1.6. Preliminary test objective type will be held in OMR based offline mode. Your Lord's what? Computer based recruitment test mode. Commission reserves the right to conduct the preliminary test either in OMR based offline mode or in CBRT mode. Then what if they want to take the process of normalization etc., moderation etc., whatever is 1.7 says the commission will normalize the scores of candidates for the computer-based tests which are conducted in multi-sessions to take into account of any variation in the question papers across different sessions. The criteria of normalization is given in Annexure 7. I have yesterday taken your lordship to the Annexure 7. Then what I was trying to further draw your lordship's attention to is 1.8. Main examination would be held in descriptive type.
Yes.
Commission reserves the right to conduct the main examination either through digital mode question paper display or conventional hard copy based question paper. This is about how the paper will be there. Then the Lord Commission may evaluate answer scripts of the main examination on digital online mode in addition to or instead of conventional evaluation. Now, what is the conventional evaluation is the next question that may fall for your Lordship's consideration. But what I was trying to submit to your Lordship was, whatever way they would like to conduct these or make the selection, they have initially stated. They have left only some options in themselves. They cannot travel beyond these options is what I am trying to submit.
Yes.
But same thing is repeated in paragraph 12.5 about the main examination. At page 374. Same version, as in 1.8.
Para 1.5. 12.5.
1.8, 1.9, my lord, the method of evaluation is given. 1.8 and 9 deal with main examination.
Yes, yes.
My lord, same thing is repeated in paragraph 12.5. At page 374.
Yes.
I'll just read again for my benefit. In respect of evaluation of the mains examination on system, the Commission will resort to digital evaluation mode or conventional mode, depending upon the administrative and operational convenience. Same language is employed here and here.
Yes, yes.
Now, my lord, we have raised an objection for issuing separate hall tickets, my lord, for the main examination. This, according to us, is compromising the sanctity of the examination. The reason what we have stated, that at the outset it may appear to be unsustainable submission, and it can be argued saying that which center a candidate gets allotted, etc., will be in the absolute prerogative of the commission. A candidate has no right to insist that he will appear for the examination from a particular center. But I am not on that power or that modus. I am on a different issue. According to me, this issuance of new hall ticket was a, an attempt or a deceptive attempt, according to me. This deceptive, my lord, attempt percolated further, my lord, in the matter of evaluation and the ultimate result. For this purpose, my lord, we have in the writ petition raised an objection to this, my lord, subsequent. My lord. Will your lordships now go to the hall ticket? That in volume 4, your lordships will get model hall tickets. At page 598. 599. At page 599.
Yes.
But your losses may take lot. At the top, it was written as hall ticket for mains examination conventional type. Kindly now, Lord, examine that hall ticket number. It is 240927550. So that's what that number. What they have done, Lord, the first four numbers appear to be the Lord represents group 1. 2409 represents group 1. Then Lord, next two numbers, that is 27, is there. 27. 27 represents the center. That is, this candidate will appear for the examination in center number 27.
Yes.
Then Lord, 550 is will be his serial number in that center. This hall ticket can be written as 2409 slash 92 slash 27 slash 550. No center has got, yesterday some submissions were made by the Advocate General saying that 18 and 19 has got more than 1000 candidates in each center. It's not that. But for each center, there can be a maximum of 999 candidates only. Not more than that. The all tickets were designed in that part. Now, what can be my objection? Is the next question. My what we have submitted before the learned judge was
Yes.
candidates were picked up, or they know the candidates who will appear from which center in advance of even his being given a hall ticket. So they have first decided upon the candidates to appear from a particular center.
In center 18 and 19, 721 and 776 candidates appeared.
On women candidates.
Not
Yes.
beyond 1000.
Not beyond that.
You are, all sides are making us work.
Overtime.
Yes.
No, in fact, when an Advocate General made submission, he said that
No, that submission was in the context of percentages.
person,
He said where a couple of thousands
that's what-
appear.
No,
It didn't mention that
No,
thousands
I-
appeared from that center.
I understand.
Specific numbers were given.
I understand. I understand they were making a reference, they saying that it's a big center, accommodating more number of candidates. My humble submission is it's not so. It is for every center 999 candidates. Nowadays, not every booth, only 1000 voters. If I am correct, not even in the elections, every booth will have only 1000 voters. Like that. Not, if this is so done, my lord, according to me, we are capable of accepting some of it. It is for the purpose of not identifying a candidate, identifying his center, then placing him in the center for various reasons which I will demonstrate later. Just as in the present stage, I will be demonstrating. Because this change is not only for this purpose, this is what I was trying to say. Therefore, our objection is that earlier in all the examinations, you have adopted a method of not making the candidates from preliminary examination to main examination, write the main examination with the hall ticket number which they had in the preliminary examination. There was no possibility of knowing which center he is writing from, what will be his hall ticket number, etc. will not be able to be that easily identified. Here, it will be easy to not grasp or not get at a candidate if I want to know at the time of correction which bundle this man's paper finds, where he did write from, etc. What is it available with the help of this particular number. Therefore, this changing the hall ticket is illegal is what I said. Try to humbly submit. Then will not kindly take the answers. At page 788. Your lordships have got this.
Yes.
Your answers. Not the it's a pro forma mirror, therefore the main hall ticket number mirror your lordships will find it different. It's a pro forma answer script. Your lordships will not find that 2409 etc. Your lordships will not find it because it was a pro forma one. Then mirror kindly have a look at what details it contains. And we may not be even required to look into the what the details are. You have the name of the candidate, his hall ticket number, etc. Then what at the center of that particular hall ticket number, your lordships will find a box saying that control bundle number at the top mirror, where it is written.
Control bundle number is in the second part.
No, mirror, after the PO.
788 के ऊपर.
अच्छा हाँ, there is one.
Control bundle number. There is a control bundle number. Then kindly come to the second portion of the word answer script.
Yes.
That bundle number is before that box.
Yes. The second one, what your lordships will get. Yes. At the bottom. Can I just take your lordships to the right hand side column?
Control bundle number is on top of the page, my lord. Top
No,
of
on
the
the
page
top of
above
the
the
page.
first box.
And at the foot of the
I'll take
two
it.
perforations.
Yes. Your lordships will get not on the right side. Your lordships will get that is some bubbling has to be done here. Your lordships what on the right side, second part. In that your lordships will get serial number of the answer booklet. Your lordships,
Yes.
in the bundle. So enough care is taken by them to identify firstly which control bundle this my paper will be there. Then what will be the serial number of my paper in that particular control bundle.
Yes.
That is what is made evident here, made explicit. My lord, this will be known to the examiner or evaluator, whoever my lord evaluates. By knowing the serial number in the control bundle number, in my humble submission, it is very clear what hall ticket it belongs to. They say that my lord, the top portion at the top will be removed and it will go to the evaluator with this second half or second part, where the evaluator also knows about the control bundle number and the serial number in the control bundle number, and he has to necessarily enter. And at the bottom of the middle portion also, it has to be entered. Control bundle number has to be entered on the left hand side. Your lordship, in the middle portion on the left hand side, control bundle number for the office use. Similar is the position, my lord, here. Then, kindly, my lord, come to the, my lord, left hand side portion of it. Horizontally, if it is put, my lord.
Yes.
Your lordships will find again it is entered here. Bundle number is entered. This is, my lord, this will be permanently retained portion. There also bundle number is written. Then serial number in the bundle number also has to be written. Similar is the case with the second evaluator, according to them.
Yes.
Now, what happens if this is clear? Each center has the 998, 998 as answer scripts, but they have not stated. Saying that answer scripts were randomized. It's not their statement. They stated saying that they are anonymous. Anonymized, what they understand or what they have communicated was what I understand. I cannot read it out. What I understand from what they stated as anonymized is that by removing the top portion, no one will be able to know the details of the candidate. Therefore, the sanctity of the examination is preserved, is what they say. My humble submission is sanctity is lost in on all courts. It is made very explicit and clear to the persons, Lord, who are undertaking the job of evaluation or who are at the helm of affairs of Lord evaluation process about whose paper is being corrected by whom, or the evaluator knows whose paper he is correcting. In such situation, if Lord, what my experience and my knowledge is that it will compromise the sanctity of the examination.
Let us go to the answer booklet of the prelims exam.
Here. Earlier page. Sorry, earlier page. That's all together. Prelims examination, firstly, more than 4 lakhs candidates or 3 lakhs etc. candidates will all have applied. Then Lord, it is corrected by a computer. It is only, my lord, an objective type examination. Can I have the benefit of hard ticket? Yeah, I may have to leave my hand. I don't think Raishek. preliminary, but preliminary examination answer book, model answer paper, my lord, is not there.
Challenge was to main exam for prelims was never put in issue, therefore it is not
So
part
we
of I'll ask them to produce.
just wanted to compare the hall tickets as to what.
I'll produce.
What difference would it have made if the hall ticket of prelims?
Very good.
But their examination mode, as you also have seen this, not seen. Firstly, lakhs of people are there. Secondly, the examination mode is different there. Correction is by,
Optical scanner we are.
but it only recognizes what is fetching to it.
I was appointed commissioner by this honorable court in one of the prelim matters earlier. The
There I
exam, my
have
friend is right. Completely different pattern. But there, the answers have to be given only in the bubble form, objective questions only. But the correction is done by the computer. And if anyone only protests, my lord, that will be manually verified. So, my lord, my learned friend is right. A completely different procedure for prelims. What we'll do is we'll also try to produce, since your lordships wanted to look at it. It's not a part of the record, but it will bear out, my lord, that this would be a different test exercise. My learned friend is now talking of a hypothetical possibility. We have an answer in our reply, we'll do it.
Yes.
Therefore, our objection was for both. That is, for changing the hall tickets and also for not the answer sheet. In respect of changing the hall, though it was not mentioned anywhere, in the counter affidavit, one of the counter affidavits, they stated that they have randomized either the names or the earlier hall ticket numbers. And thereafter, they have generated new hall. This is their contention. Now, the learned judge, because yesterday comment was made on the learned judge, saying that the learned judge did not really see to that. If it is randomized, what it was submitted was, there can be a male, then a female, then a transgender, or there was a PWD, or someone else, or there can be a person that or all of them, they need not come over and see their but they can be coming or they need to be mixed up in the randomization. There is no possibility of a continuous 10 females, 100 females, or total number of females that one takes will not be a possibility is what was submitted. What they say is we have randomized. My land friend Mr. Niranjan was effectively substituted. He said that we have randomized. Thereafter, we have evolved another method of segregating the candidates. What they say, we wanted to be some facility which is part of the one of the instructions in the notification is that PWD will have some kind of arrangements made for them to enable them to conduct the examination. Therefore, we have first noticed among the randomized network the candidates who have got typically person 50, we have identified person 50 the first way of dealing with the randomized network. Then they say that we have segregated female. Then we have come to male. So we have segregated. Then PWD people will come in first. Then female. Then what male. This is how we have segregated. Thereafter we have given them the market. That is what was stated. Assuming it's not as if not all PWD candidates were, but supposing they have been segregated. If they have been segregated, then all PWD candidates
Sorry.
shall have serial numbers to write in a particular center, etc. It's not done. All PWD candidates were not distributed, I may say, either for some reason or the other. In all, they were given accommodation of multiple cells. Therefore, this segregation did not end anywhere. Then next is women. Now what they say is, women candidates are segregated for the purpose of allocating them to women colleges. It did not happen so often. Only, if I am correct, 2 colleges were chosen for allocation of 2 women colleges were chosen for allocation of women candidates. There were other women colleges where male and female were. If I am correct, there were in all 8 centers which were there in the women college.
Three centers. But not to interrupt my friend, so that the sequence comes out clearly, so that your lordships can appreciate my learned friend's arguments properly. 31,000, everybody randomized, my lord. Nothing segregation done. Now, then first, my lord, PWD candidates are allotted to centers which are PWD friendly. So, my lord, a PWD candidate could come at 25, he'll be 98, 135, 440. So, for the PWD candidates, my lord, in that random numbers, whichever came in the first sequence from 25 onwards, PWD centers are allotted. My lord, there were 3 centers which were decided, my lord, because they were from women colleges where only women candidates were to be allotted because of some reasons. They figured, my lord, that a women candidate could figure it serial number 3, first women candidate, second women candidate could be at 4, third women candidate could be at 8, 12, 15, etc. So first, my lord, only those 3 women college centers, the women candidates after randomization who came in the beginning, they were allotted to these 3 women colleges. So, my lord, once PWD candidates are allotted, once sufficient women candidates through those 3 centers were allotted, there were many more women candidates, but much more male candidates left thereafter. Then, my lord, following the randomization sequence only, center number 1, we went from 1 to, if suppose it has, my lord, 400 students. We went to 1 to 400, but if within the first 400, 40 had already gone out, or 100 had gone out, my lord, to this PWD and 3 women colleges, we went from 1 to 500 for first center. Second center would start from 501. Let's say if there are 500 candidates, between 500 to 1000. If 200 candidates had already been moved because of PWD and women, we went only by sequence. So, my lord, the randomization happened by computer, no manual intervention. 31,000 candidates all get random numbers. The first ranking PWD candidates are allotted to the PWD friendly centers. The first ranking women candidates are allotted to 3 exclusive women centers. After that, all the residual candidates are allotted in terms of the sequence of the random numbers from center number 1 to the last center. So, this whole process was automated where we had everything was directly from the first ranking, but this was the process.
I can only say that they are not been instructed properly. But I can only say that. But if I am correct, Lord, I have got the data. Lord, center number 27 is a women's college. If your lordship takes, Lord, my written submission, if your lordship, at page 21 of my written submission. Lord, written submissions, Lord, were filed in data till 107, and your lordship have got the copy of my written submission. Your lordship got page 21 at the top, paragraph 71 at the bottom. Your lordship got.
Yes, yes.
Conversely, center number 27, your lordship got. Then center number 7, your lordship sees the college's name, Spurti Women's Degree College. Then center number 9, Megha Women's Degree College. Center number 37, BVRIT, so and so. Center number 17, Indira Priyadarshini, etc. I have named These were the centers other than what they say that only 2 or 3 centers. But my humble submission is the number I have not counted, but there are more than 3 centers. They have selectively chosen female candidates to particular 2 centers, 18, 19, etc. And other colleges, it was mixed in the sense that male and female were allocated. Why it was so is not for us. They have their own reasons. I will not say that they have ignorantly done. I say that they have done with all knowledge of what they are doing. According to me, it was with a view to facilitate some people. Is the submission that I was trying to make. In so doing, they claimed randomization. They have not filed the list of randomized members reported. To say that there was a randomization, just an averment, was not enough. The hall ticket numbers show that despite their claim of randomization, certain women continuously come, certain male continuously come, or male and women continuously come. And this segregation where it did go is nobody's knowledge. They claim that there was a segregation. It did not really. Therefore, this kind of preparation of all tickets and allotting them to centers was totally, according to me. They may say that there is a genuine, bona fide, most transparent reason of or avoid reason for doing something. But according to me, ultimately it turned out to be, as I have demonstrated in my description, saying that the centers which they have specifically chosen have turned out to be a green class road, and other centers turned out to be something else. That is the situation. That's where we have challenged it that way. And this, if they have resorted to randomize, this is what exactly was considered. Though in the case before the Honorable Supreme Court, Delhi Nawaz Selection Board, Services Selection Board, and this is the differences of it. There also, they claim that there was a randomization. But persons from a particular family in that case appeared from a particular center sitting side by side. This was later noticed by the officials. Officials, they thought to cancel it. That cancellation was questioned. There also the same claim of randomization was made. But the fact remains that despite randomization claim, etc., the fact remains that some persons sat side by side and expected or wanted result was achieved, and Supreme Court said that the decision taken by the authorities, there was a government change, etc. There also, a decision was taken by the government to cancel this plan. Court said that we perform the cancellation because this kind of manipulation, maneuvering is nothing but, in my humble submission, a design what is called as undetectable things. It may be not that some persons are caught copying. There was an investigation in a criminal case, but in every case, prior investigation in an investigation report or some report, they are not doing it. But supposing I can submit your lordship saying that by these things, what has happened, there is definitely a scope for your lordship to come to a conclusion in my humble submission that everything is staged. I just answer. Answer. There is one more submission that I may have to make on your this answer, the model answer paper. The barcode which appears is also written. They say that not, of course, barcode necessarily have to be retained, not what they say, it is for the purpose of again matching the answer sheet with the particulars of the candidate. But these particulars are continuing with the answer sheet. With the barcode on retained on the left hand side. In fact, they have to compare it with the top portion. But it will not be even necessary also. How will this so-called transparent way of giving this answer book? Everyone can not perhaps scan it, which candidate it belongs to. As the barcode is retained in the answer book, which will go to the examiner. Each examiner will go, he will be able to know the details of the examinee. Therefore, what they have done here, what is nothing but a man.
Have you covered?
I have covered about the 2 points. I may have to take about another 3 points. Only 3 more points.
So request to speeden up would be just stating the obvious, but because other councils would also be assisting
One
and
more hour for that time.
Because I'll be going after Mr. Rao if you lordship will permit.
that is something again that we'll see when the time comes. So, but
I try to be fast.
otherwise the focus gets lost.
Sorry if I am repeating. Perhaps I have not repeated much.
So if you could quickly make your points, because written submissions were only for this purpose. And these written submissions of yours are in 73 pages, so it more than the writ petition perhaps.
we are finding it difficult to make a reply because these are the things not argued before the learned single judge, nor a part of a writ petition. How are we going to respond to that? I do not know, my lord. Repeatedly, twice it was brought to your lordship kind notice.
No, but don't enlarge the debate about all these things.
Definitely. One question, 1 hour, my lord. Surendra Rao, my lord. Lean and hungry, always dangerous. One question, 1 hour, my lord.
Perhaps my benefits comments do not apply to every lean man.
So after him, learned senior would be,
Because I am ready, my lord, subject to your lordship's permission.
and then Mr. Reddy Rachna.
Yes. I think some and Mr.
I think there's also
Vidyasagar
Mr.
Garu.
Vidyasagar is also.
Milord, I am also there, Milord.
Oh, you are appearing from US.
Intercontinental, my lord.
Yes, yes.
And in practicality,
Maybe that my license from elsewhere get the chance on the.
Today, the largest communication satellite is perhaps launched already
Yes.
by ISRO.
Yes.
It's just 9 hours behind us, your lordships, as we speak.
So
That
if,
Around 10,
if he
10 and
doesn't
a half
get the
hours.
chance, then his bedtime would come.
Yes, it is actually his bedtime right now.
No, now it, acha, haan.
He's 9 hours behind us,
So
your
it
lordship.
would be around.
Now around 12 noon, sir. 12 midnight.
12
Oh, it's
midnight.
12 midnight there.
Yes.
Yes, yes.
It's in
My-
California.
my learned friend is literally burning midnight oil.
So in fact, you can wake up and then take some rest. So we go
So may-
sequentially.
Yes.
So we would only reiterate our request that let us be time bound specific, because not only this matter but other matters are also in the list and waiting for the next day. And the capacity of the judge to patience.
May seek an indulgence, Milord, then it may be tomorrow my turn may come.
Tomorrow
29,
is
29.
Xmas.
Tomorrow is Christmas.
Not
India
tomorrow,
also is
Monday.
Christmas.
Let's see by 4:15 what transpires. But we expect that at least 3-4 of you could be completing, so that
They will be completing.
very
Grateful, my lord, grateful.
Okay.
Great.